With just 1 week until senators are set to leave Washington, D.C. for their annual August recess, the confirmation of Donald Trump's former personal lawyer as Attorney General remains on hold due to a crisis of his own making. Republican Senators Thom Tillis of North Carolina and John Cornyn of Texas are blocking Todd Blanche's nomination from passing through the Judiciary Committee until they get in writing from Donald Trump that his $1.776 billion anti-weaponization fund is officially dead. It's pretty clear that Donald Trump doesn't want to give up the settlement or the IRS immunity for him and his family that comes with it. This morning, Donald Trump fired off this lengthy social media post calling out Senator Cornyn for stalling Blanche's nomination. Seemingly in defense of his fellow Republican, Senator Tillis responded with his own post. Quote, "The president made it clear today that the so-called anti-weaponization fund is still alive, which is exactly why we are attempting to formally end it. Senator Cornyn and I have been working with acting AG Todd Blanche to end the anti-weaponization fund, and he has been forthright, thoughtful, and patient. It's a shame his confirmation has hit a snag, only because an incompetent personal advisor to the president refuses to amend the bogus settlement. I will continue working in good faith to put an end to this legal political albatross and prevent any potential misallocation of taxpayer dollars." Well, less than an hour later, Donald Trump, he said this.
This is being done by a senator, and I don't really blame him, to be honest with you. I endorsed his opponent, and as soon as I endorsed his opponent went through the roof, and he won the primary election in Texas.
Do you agree, just to be clear, do you agree with the acting attorney general that the anti-weaponization fund is dead? And why not just put that in writing?
It is dead, but, I wish it weren't, to be honest with you.
Except it appears to not be dead because Cornyn and Tillis still haven't said that that agreement has been made. So that was followed by news tonight that Donald Trump is appealing a federal judge's order finding he filed a bad faith $10 billion lawsuit in order to reach this very settlement that resulted in the anti-weaponization fund. CNBC reports Trump, two of his adult sons, and the Trump Organization, along with two of their attorneys, said in a joint filing Friday afternoon that they are appealing Judge Kathleen Williams' scathing order to the U.S. Court of Appeals for the 11th Circuit. Williams had ruled July 13th that the lawsuit, ostensibly stemming from the leak of Trump's tax returns by an ex-IRS employee years earlier, was in fact brought to provide judicial legitimacy for a settlement that had no viable basis in law or fact. After Friday's appeal notice was filed, a spokesman for Trump's legal team repeated a prior statement slamming the IRS leak and declaring President Trump continues to hold those who wrong America and Americans accountable. Also tonight, MS Now, it's confirmed that the Justice Department moved to drop felony charges against former Olympian David Hearn after acknowledging that the damage to the Lincoln Memorial reflecting pool was caused by a flawed installation rather than vandalism. The motion to dismiss was filed by D.C. Attorney Jeanine Pirro after prosecutors concluded that the damage attributed to Hearn stemmed from defects in the installation of the reflecting pool's liner. The filing said information obtained after the indictment showed the damage was caused by, quote, botched work performed by the project's contractor, not by criminal conduct. Remember, it was Donald Trump's chosen contractor who did this very work, and it was Trump himself who made this following claim.
They cut it up with a buck's knife and tried to destroy it. These people are sick. They ripped a scar 350 feet long through the side of the reflecting pool.
And Jeanine Pirro said they had beyond a reasonable doubt that Hearn had in fact ripped it up. Joining us now is Barbara McQuade, former U.S. attorney and law professor at the University of Michigan Law School. She is also an MS Now legal analyst. She is the author of The Fix, Saving America from the Corruption of a Mob-Style Government. Barbara, first I want to start with the reflecting pool because I think it sets up everything else around this. Clearly false statements made by the president and Jeanine Pirro that his own people then aren't able to prove in the court of law. What damage does filing these types of prosecutions, from trying to make the Subway sandwich thrower a felony crime to the reflecting pool indictment, do to the credibility of the Department of Justice?
Boy, Vaughn, I really worry what it does because it means that members of the public can no longer trust the Justice Department to be bringing cases in good faith. The timing of this dismissal is so suspect. It came right after the defense filed a motion to disclose grand jury materials because of this very issue. A witness came into the grand jury room, according to the transcript, testified he didn't know anything about the value of the damage that had been done by Mr. Hearn. He leaves the room and 20 minutes later comes back and says, oh yeah, it was more than $1,000, which is what the statute requires. It was so implausible that the defense team filed a motion to find out everything that occurred before the grand jury. And then the very next day, we see this motion to dismiss. This confirms what most people have suspected all along, that there was no there. But it appears that this case had come to roost, that they were about to be discovered, that there really was no basis for this case. And so rather than be humiliated, Jeanine Pirro chose to voluntarily dismiss the case. But it really harms not just these prosecutions, but the other hundreds and thousands of cases that are brought every day that are legitimate, cases of bank robbery or human trafficking. And jurors are now going to rightfully be suspicious when the Justice Department or the FBI tells them anything.
We're watching a correction, of course, Barbara, it seems like in real time after some of these claims are made. And I just think for everybody watching, this is the motion to dismiss. And the end of it says, quote, finally, a recent visual inspection showed damage throughout the reflecting pool, even in the middle of the pool where a vandal would not likely have attempted to peel the lining. Given all of this newly discovered information, it is difficult to attribute the widespread damage to the reflecting pool to vandalism, let alone to establish that fact beyond a reasonable doubt. I read that because it is signed, respectfully submitted, Jeanine Pirro, the U.S. Attorney herself. But on that line of, right, sort of the course correction being made from previous decisions by this Department of Justice, one of them is around the anti-weaponization fund. And well, the president today claimed that it's dead. Senator Tillis is saying otherwise. My question for you, Barbara, is how can the Department of Justice actually roll back the fund and essentially reverse course on that $1.76 billion and make this formal that it is, in fact, not going anywhere?
Well, as we've heard, Vaughn, Todd Blanche has said in confirmation hearings now twice that it's dead. They're not moving forward on it. That statement alone, Judge Kathleen Williams says, demonstrates that this was not an arm's length negotiation, because if it were, one party to the case, like Todd Blanche, can't just unilaterally say the thing's dead. It requires both parties to say that. And we have Donald Trump saying just the opposite. And so I think it is very understandable that people want to see in writing the idea that this case is withdrawn, because otherwise it still stands. It's a written document. There is a settlement. And, settlement agreements are contracts between the Justice Department and Donald Trump as an individual in this case. And so representations orally by Todd Blanche really aren't very meaningful. And so I think what you would need is to see both parties file some agreement that says they have withdrawn this agreement and that this deal is no longer going forward. But when President Trump himself continues to say that he thinks it is a valid weaponization fund, when he says they're going to appeal the decision by Judge Williams, finding that this was not an arm's length agreement and there was no adversity to the parties and it was just a sham on the court. I think that people are, Senator Tillis and Senator Cornyn are well advised to demand this to be in writing. Otherwise, it's not valid.